from the High Court of Kano State. We welcome you to the program. We want to recognize our distinguished guests who are the viewing center of the Glass House of Kogi State. We want to recognize Honorable Justice M.E. Umar, Honorable Justice Salisu Umar, Honorable Justice Moses Guatana. We also want to recognize Senior Advocate Abdullah Yaya, Senior Advocate of Nigeria. We welcome you to the program. Thank you very much for coming. We want to recognize Hajia Musa Yusuf Falilat. She's the Solicitor General and Permanent Secretary of the Ministry of Justice, Kogi State. We want to welcome you to the session today. We want to welcome our Commander, Nkechi Franka Okechukwu, from the Directorate of Legal Services of the Nigerian Navy. Welcome you to the program. Other legal practitioner, Mr. H.M. Ibega, we welcome you to the program. The Chairman of the MBA Buhari branch, Mr. P.B. DAUDU, Senior Advocate of Nigeria, we want to welcome you to the program. We want to welcome the Chairman of the MBA Banawa branch. We want to welcome you to the program. Thank you very much. Before I hand over to the session chair, I would just like to briefly read the profile of our panelists to give us an insight into their background and, to prepare us for what to expect. I'll start with the Honorable Justice Professor Alaba Omolai Ajile. He's a former judge of the High Court of Kogi State. He's currently a visiting professor at the National Open University of Nigeria. On Tuesday, he will be inducted a fellow of the Chartered Institute of Mediators and Conciliators. He's a resource person for several organizations, international organizations and national organizations such as the National Judicial Institute, the National Institute of Advanced Legal Studies, the Rule of Law Development Foundation. He's a scholar of no mean repute with over 90 academic papers published and delivered in national and international conferences and journals. He's acknowledged as a leading authority in the law of electronic evidence in Nigeria and Africa, and is the chief consultant and CEO of Forensic Electronic and Digital Law Consultancy. He's a multiple award winner, among which is a certificate of nomination as the 2016 Walden University Outstanding Alumni Award as a leader of positive change in the legal profession. He retired from judicial service in the year 2023 with an unblemished record. Please, may we give it up for him. A very big round of applause. A very big round of applause. We welcome you to the program, sir. Next, we want to just go through the brief profile of Professor S.C. Horn, Senior Advocate of Nigeria. He's a promised and distinguished senior advocate, having demonstrated excellence in the legal practice and advocacy over the years. His career spans various areas of law, including litigation, commercial law, corporate law, public law, constitutional law, and human rights, in advocating for the protection of citizens' rights and rule of law. Professor S.T. Horn, Senior Advocate of Nigeria, has contributed immensely to the development of Benue State and Nigeria at large. He has influenced the employment and appointment of many Nigerians and lawyers as well into several positions, both locally and internationally. He's an established author of several books, which we all know are used in very distinguished libraries, courts, and referenced all over Nigeria and across the world. He's also a chief, having been awarded several titles, won by the Boko Traditional Council in 2017, pronouncing this Afa Atidu Uboko. I'm sure he would give us the interpretation of these heavy titles, very, very heavy titles when it comes. He's a fellow of Chartered Institute of Arbitrators, and he's earned recognition not only in Nigeria, but also internationally for his legal expertise, his contributions to development of law and justice. Please, may we give Chief Sebastian Horn, Senior Advocate of Nigeria, a huge round of applause. We also want to recognize Mr. Simon Lowe. He's an Assistant Commissioner of Police, Deputy Deputy, thank you very much for the correction, Deputy Commissioner of Police, and the Senior Advocate of Nigeria. He's made history by becoming the first Nigerian police officer to be awarded the prestigious rank of Senior Advocate of Nigeria in 2021. DCP Simon Lowe serves at the Force Legal Department in Abuja and has been involved in several high-profile cases as prosecuting counsel, earning a reputation as a determined advocate for justice and human rights. His promotion to the rank of Senior Advocate of Nigeria was part of a selection by the Legal Practitioners Privileges Committee recognizing the learned silk's exceptional contributions to law enforcement and legal excellence. We welcome you, ACP. DCP Simon Lowe, Senior Advocate of Nigeria. Thank you very much. I believe my job here is done, so we can start in earnest. I would hand over to the session manager, my Lord, the Honorable Justice Oredola. Thank you very much, sir.
Good morning, distinguished participants and learned colleagues. My Lord, Professor and Professor S.T. Horn and other resource person, we are starting a bit about an hour behind schedule, so we have to have an effective alternate case management called time management. So let me just preface today's day 3, session 1 of the Rule of Law Development Foundation's annual conference, 6th annual criminal law review conference, to place on record that this morning's session is very, very crucial and vital. And why this is so is because in the course of hearing in a criminal matter, one of the most crucial, burdensome, cumbersome, and that is capable of torpedoing a trial at the end of the day at any level is this issue of confessional statement. So I will humbly beseech participants to be very, very astute in being creative in their listening and taking notes, because we are getting, in fact, this morning's session, we can tag it the session of professors. And these are people who are, I mean, if you can say behind their back, say it in their presence. They are brilliant. They have, in fact, they have paid their dues. So we are going to imbibe from their wealth of experience. I want to assure you that at the end of the day, we will all go away from this place richer and will gain more benefits. So without, I leave all the comments of mine till the end of the day after they have delivered their papers and we have our interactive session. So as we want to do, the lead presenter of the paper will take 10 minutes. My Lord is my brother. He doesn't even need an application for extension of time, but I know he won't need it. But he has 30 minutes. So my Lord, you are welcome to the poster. We are happy to have you. Yes. You are tired, but you can see that you are not tired.
My Lord, the Chairman of Session, Honorable Justice Oredola, Justice Court of Appeal, retired, my fellow panelists, Chief Professor S.T. Horn, Senior Advocate of Nigeria, DCP Simon Lowe, Senior Advocate of Nigeria, Honorable Justice Fatima Adamu, Abdullahi Yahya, Senior Advocate of Nigeria, and at the LOKOJA end, permit me to recognize my former colleagues, Honorable Justice M.E. Umar, Justice Angelina Saliu, Justice Guatana, and Justice Salisu Umar. Well, first and foremost, let me appreciate the Rule of Law Development Foundation for giving us yet another opportunity to share our thoughts on a very topical issue. Like I said yesterday, I've always been part of the Rule of Law Development Foundation. And so if this is the 6th edition of the program, it means this will be my 6th lecture in this place. I thought you, thank you very much. So this year, I've been given a very controversial topic to treat, and it's about electronic recording, essentially admissibility of electronic recording of confessional statements. And you will agree with me that this is an aspect of the law that is giving so much challenges, not only to lawyers, but even to the courts. And this year, 2 cases of the Supreme Court were given to me to review. But I felt that the review will not be complete until we have a holistic review of all the cases. And so I have added 2 other Supreme Court cases. Unaja 4 and FRN was given to me to discuss. Then there is a, maybe we should start from that. But before then, just going straight, because of our time, we have had so much time wasted, and so we just go straight to the, I don't want to go into all these preambles, what is confession, maybe just one statement on each. We know, like the chairman said, confessional statements, they constitute a major arm of criminal justice system in Nigeria. And the value of confessional statements to the administration of criminal justice is invaluable. Ordinarily, nobody will want to incriminate himself over an offense committed. And so, if there is a confession, you are talking about an admission by somebody who has committed an offense that, yes, I have done it. This is not, it should not be taken as, it's a matter that ordinarily goes to conscience. But we know in our system, it's not every confession that is made voluntarily. And that is where the problem arises. And the law recognizes this fact, that confessions can be extracted from defendants. So, in Section 29 of the Evidence Act, it is stated only confessional statements that are voluntary are admissible. So the court will ordinarily admit confessions that are proved to them to be voluntary. Of course, and this is a global phenomenon, that courts will only take confessional statements that are voluntary. Then the law envisages again that confessions may be involuntary, and therefore it could be challenged. From my experience on the bench, I discovered that there was hardly any statement, any confessional statement that was to be tendered, that there will be no objection. And we have series of objections. The law allows objections against confessions only on one ground, that it is involuntary. But there is hardly any point that will not be raised against confessions. You know, so much so that you will hear that the defender did not make it. That one should not be any basis of objection. So the basic ground stipulated under section 29 for objecting to confessions is that that confession is involuntary. Then there is what we call trial within trial. The law, we have this amendment of the law in New Evidence Act in 2011. Until there was an objection against a confession, you will not be talking about trial within trial. But if you look at section 29, 1 to 3, it stipulates the conditions. And particularly, subsection 3 allows that the court on its own, if it finds that the confession was involuntarily made, can raise the issue and call for trial within trial. In most cases, in court, we don't wait for that. Confessions are challenged. And immediately a confession is challenged on the basis of involuntariness, the court is bound to take the step of trial within trial. So I have it here, the trial within trial, in paragraph 4, well explained there. Then, going to the main issue for discussion, that is electronic evidence in confessional statements, and particularly electronic recording of confessional statements. But meanwhile, I have traced the history of electronic evidence in confessional statements to the enactment of the Administration of Criminal Justice Law of Lagos State in 2011. That was the first time we had it. And the law was very clear. For instance, in section 9.3 of that law, it stipulates that where any person who is arrested with or without warrant, blah, 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 volunteers to make a statement, the police shall ensure, that is the language of the Lagos law, that the shall ensure that the statement is made, shall ensure that the making and taking of the statement is recorded on video. And the said recording and copies thereof may be produced at the trial. So I want you to take note of the fact that the Lagos law that originated this process used the word shall. Then there is the other arm of it about the presence of lawyers or other persons. Again, the Lagos law uses the word shall. So if I read on, and it provided that in the absence of video facility, so that is an alternative. In the absence of video alternative, that statement shall be in writing in the presence of a legal practitioner of his choice. That is the Lagos law. It's still extant. Then, it came before the Administration of Criminal Justice Act That's the national law now of 2015. So apparently, Lagos took the lead. The national legislature saw what Lagos did and now proceeded to adapt it. Although in adapting it, I will say the adaptation created problem. Because instead of using shall in the law of Lagos, Administration of Criminal Justice Act 2015, that is ACJA, now uses the word may for both situations. In recording the statement, video recording the statement, that it may be recorded electronically on retrievable video compact disc or such other audiovisual means. That is section 15.4. Then the presence of legal practitioner and the other one, section 17.2, also uses the word may. So my submission here is, if you want to copy, it is better to copy properly. And if you will not, why not? So if you are copying Lagos, Lagos used shall. If the ACJA had used shall for video recording and the recording of statements, the presence of legal practitioners and others, probably the problem we are running into now will have been avoided. So I want to say very assertively that it is the use of this may that has brought about all the challenges in the interpretation of what should be the attitude of the court. So we have this. And of course, after the enactment of ACJA, states were required to domesticate it in their laws. And they did. And we now have virtually in all the states of the Federation, administration of justice, criminal justice laws all over the state. And it is like most of these states preferred ACJA. So instead of using shall, for example, in my state, KOGI state, instead of using shall, it is may that we have. So I want to believe, I didn't carry out the research to know the number of states, but I know Ondo State uses shall. But majority of states in Nigeria, they used may. And so we had problems at the High Court level and at the Court of Appeal level in the interpretation of Section 15.4 and Section 17.2 of ACJA. In fact, I would say the jurisprudence arena in this area until now that we are getting to a destination, so to say, has been very chaotic. We have so many cases of the Court of Appeal that are conflicting on this issue. You will see one case today, may means shall, and it is mandatory that there should be video recording. Tomorrow you will see another one, may means may, and it is discretionary. And so there is option for the police and security officers in recording those statements. So we have that situation on ground. Until now, we have these 4 cases that I have discovered that the Supreme Court had treated. I mean, treated the matter of Section 15.4 and 17.2 of ACJA. One is Taiwo FRN, Charles versus the State of Lagos. Then we have the Unaja 4 FRN and Akaize against FRN. These are Supreme Court decisions on either Section 15.4 and 17.2 or Section 9.3 of the Lagos law. For instance, Charles versus the state is about Section 9.3 of the Administration of Criminal Justice Law of Lagos State. But others, Taiwo versus FRN, Unaja 4 versus FRN, and Akaize FRN, they are about Section 15.4 and Section 17.2 of HARDSHIP. The relevant facts of these cases are stated here. Well, there is no, I will not go into details about them, but the point I want to make here is that as there were conflicting decisions at the High Court and the Court of Appeal, we have also found that it's like nothing has changed at the Supreme Court, because we now have divergent views of their lordships in the interpretation of these relevant sections. So, for instance, in Taiwo versus FRN, the man was charged. He confessed to the commission of the offense. Then, at the end of the day, he was charged for these cannabis sativa, India hemp, being in possession of them. At the end, he was sentenced to 25 years imprisonment. He admitted the offense at the trial court on the basis of a confessional statement. And it was on the basis of that confessional statement he was sentenced. But on appeal, he took up the matter on the issue of compliance with Section 17.2. That requires that a legal practitioner must be present while taking such statement. The Court of Appeal ruled that the use of may under that Section 17.2 was discretionary. That is the Supreme Court. That may, according to the Court of Appeal and the Supreme Court, the Court of Appeal held, overturned the decision of the High Court and ruled that may there was optional and will not be the basis. And that confessional statement, since it did not comply with the provisions of Section 17.2, it was inadmissible, because may, according to the Court of Appeal and the Supreme Court, means discretionary. It's a discretion. So that decision was in 2022. That is Taiwo versus FRN 2022. Well, there's no problem with Charles versus the state, as I mentioned earlier. It is based on the decision in Lagos, the law in Lagos, where the use of shall, and of course, the Court of Appeal and the Supreme Court, and the High Court, didn't have any problem construing the word shall to mean that shall should be mandatory. So there's no problem about that. Take note, I've said, Taiwo versus FRN, the Supreme Court says may is discretionary. Then we now have this Unaja 4 versus FRN, together with Akaize. The two cases, they happened at the same time. Some people were traveling out of the country. I think they were loaded with some dollars, which they did not declare at the airport. Of course, the law says if you have above $10,000, there must be a formal declaration. But they did not make that declaration, and they were caught. So then they took their statement And at the end of the day, at the trial, they made confessional statements. At the trial, there was an objection to the admissibility of the confessional statements. The court entered into trial within trial and also found that, of course, the issue of section 15.2 and 17.2 of Aclrc, came up for determination. The Court of Appeal in Nigeria decided that may in section 15.4 and 17.2 means it's mandatory, that it was mandatory for the police to have complied with section 15.2 and 15.4 and 17.2 of Aclrc. So that is the situation on ground. In 2022, Supreme Court said may means may, and it is optional. In 2024, in Nigeria 4 and Akaize, the Supreme Court says may means shall, and it is compulsory that those sections must be complied with. I mean, as trial court judges, you can imagine the problem that this one, has posed and continues to pose even up to today. But we are progressing. What are the controversies? What are the issues at stake? I try to explain here that whenever issues of construction of section 15.4 and 17.2 of Aclrc, whenever it comes up, usually you hear issues related to the effect that admissibility of confessional statement goes to the application of section 15.2 and 15.4 and 17.2. Issues over there relate to the weight to be attached and not admissibility per se. This is one of the issues that is usually raised. That Aclrc, Administration of Criminal Justice Act, is a procedural law. You also hear that. And it cannot override a substantive law. You also hear that Evidence Act, which is the substantive law on evidence, is the only law that should be applicable. And when you talk about admissibility of confessional statements, the only section of the law that guides it is section 29. These are the types of arguments. I think I've given about 4 of them. Whether to section 29 of the Evidence Act exclusively governs the admissibility of confessional statement. Whether Aclrc, being a procedural law, can take precedence over the Evidence Act. So we have cases up to the Supreme Court now, of course. But before now, mainly at the Court of Appeal, where you will hear when objection is raised against this section, they will tell you, well, sorry, the applicable law is section 29 of the Evidence Act. And Aclrc is only procedural. And procedural law cannot override substantive law. Then, of course, another basic issue is whether may. The actual interpret, what is the meaning of may under section 15.4 and 17.2. So I have tried to articulate these 4 issues into 2 main questions. And the first question is, which I want to attempt to answer here. Does the Evidence Act exclusively govern admissibility of evidence, particularly confessional statements? And does it take precedence over ACJA? I want us to attempt to answer this question. Number two, I also want us to attempt to answer the question, what is the proper interpretation of the word may under section 15.2, 15.4, and 17.2 of ACJA? As a threshold point, I refer to the statement of Roosevelt in a particular case. I mentioned the case there, Owuruke and COP. That was in 2015. Because when I read Ogunwumeju, JSC, in, I think in Akaize, she mentioned that since 2015, the court had taken a position to say that may, under section 15.4 and 17.2 of ACJA, shall be shall and be mandatory. But actually what happened in 2015, the case in 2015 in the Supreme Court did not decide directly that point. It was only an obiter of Roosevelt, you know, and of course it was in form of a recommendation. Roosevelt in 2015, this is what he said in the case I have just mentioned, Owuruke and COP. He said, he seriously recommended that confessional statements should only be taken from the suspect if and only if counsel is present, or in the presence of a legal representative. Something. So it was an obiter. So this particular matter came before the Court of Appeal, and Abiru, JCA, now JSC, looked into this, the statement of Roosevelt, and this is what his lordship, you know, said. In fact, the basic point is I said, well, what Roosevelt said in 2015 was an obiter. It was just a mere recommendation. It was not, what he said there was not a ratio decidendi of that case. And I have quoted Abiru, JCA, as he then was there. He said the statement was only a recommendation and not the ratio of the decision of the Supreme Court in the case. And he explained the principles of judicial precedence. And specifically, he said the ratio decidendi of a case represents the legal reason and principle, blah, blah, blah. Then the above statement of Roosevelt, JSC, was an obiter dictum. So it was not a decision of the Supreme Court per se. It was only a recommendation or an obiter dictum. It is straight law that an obiter dictum or a recommendation of a higher court does not constitute a binding judicial precedent. And in that case, Justice Abiru departed from that decision. He used he leveraged on this principle of law to depart from the case before him, where the issue of may came up for consideration. In that case, may was said to be mandatory, but at the end of the day, Abiru JCA, as it then was, said no, may is voluntary, is optional. So, well, I have clarified Charles versus FRN to the extent that we don't have problem with it. That case interpreted Lagos law. Lagos law uses shall in both spheres. So now, question number one, does the evidence that exclusively govern the admissibility of evidence? So the argument on this point usually revolves around the point that an objection that the provision of section 15.4.2 of ACJA were not complied with in making confessional statement it's not a ground that focuses on involuntariness. Lawyers here, maybe some of us who have made that type of, we have raised such objections or made such arguments. You know, it goes on to say further that it's not within the scope of admissibility under Section 29. So as far as this line of thought is concerned, anything about admissibility of confessional statement, it goes straight to Section 29, period. So then it is often argued that what the court is required to do when there is non-compliance with provision of 15.4 and 17 is to admit the extrajudicial statement in evidence and decide what probative value to attach to it at the point of evaluation. What goes with this argument, again, is the fact that it is always taken as being Section 15.4 and Section 17.2 are always taken as being analogous with the judge's rules. And of course, as we know, the law is that if there's any violation against the judge's rule, it does not go into the issue of admissibility. And so that is the argument, and that is the reasoning of this, of the basis of the reasoning of this argument, that Section 15.4, Section 17.2, they relate to judge's rule. And you don't use it as a basis to reject any confessional statements. So now, my analysis of it is this. Taiwo and FRN, I have explained it, follow this type of reasoning. That yes, both sections 15.4 and 17.2 of ACJA, they do not per se relate to admissibility of confessional statement. That the relevant section for consideration is Section 29 of the Evidence Act. And if there is breach of it, the breach is just like a breach of the judge's rules. And the effect is not to reject the statement, but only to wait at the judgment stage to determine whether it has weight or not. So that is the position in Taiwo and Taiwo. And of course, I have quoted the Supreme Court here. I think it's relevant to read. Admissibility of confessional statement is not dependent on the presence of counsel. So the Supreme Court in Taiwo is saying that the fact that a counsel was not at the point of the recording of a statement will not affect its admissibility or inadmissibility. The said Section 17.2 cannot override clear provisions of Evidence Act. So that is the position. There is further elaboration, which time will not allow us to read here. So then, I go to the divergent view in UNAJA 4 and FRN. That was in 2024. So a contrary position was taken by the Supreme Court in UNAJA 4 versus FRN, where the court held that the admissibility of confessions and admissions is dependent upon there being a video recording, subject to certain exceptions. Failure to follow the stipulated procedure under Section 15.4 and 17.2 of ACJA was held to be fatal. I don't know if you can see this conflict now. Are you following my discussion? Good. So, in 2022, Taiwo, it is optional. It does not affect admissibility. It only goes to the way. It is like breaching the judge's rules. In 2024, it is compulsory. And if you don't follow the stipulated rule, the statement is useless and it is fatal to the case. I have quoted the Supreme Court here. I don't know if there's any relevant aspect I can read. Okay, well, it says Sections 15.4 and 17.2 of ACJA impose a duty on public functionaries, police officers, and to record electronically on a retrievable video compact disc or such other audio the confessional statement of a suspect. So the provisions are for the benefit of private citizens. So, and so that the enormous power of the police or other enforcement may not be abused. So the Supreme Court is now giving basis why may, under those sections, should be made compulsory. That the power to take confessional statements, as, of course, as we all know, and the Supreme Court too knows, and is stating it, but I don't know whether my brother Lyron, Love, yeah, we agree with me. The general attitude is that there can hardly be any statement, a confessional statement, that the police has not either used force or inducement, or, I mean, this is the general attitude. And the Supreme Court is reflecting it, that if we have that type of attitude, then the best thing to do is to make it compulsory. That, in Nigeria for extensively, the Supreme Court quoted the Court of Appeal, Ekanem, JCA, and Ekanem elaborated on it so much, you know, that you cannot, the only way, another way of proving that a particular statement is voluntary is to produce the video or have evidence of a legal practitioner available. So undoubtedly, in the course of taking or recording the alleged confessional statement, the officers of the EFCC, that was the applicable institution in that case, did not deem it imperative or expedient to use electronically retrievable video compact disc. So there is equally no doubt that the purported respondent statements were not recorded in presence of legal practitioner and so on and so forth. And thus, there is no gainsaying the fact that failure to perform the act in accordance with the dictates of the provisions of the law will be deemed to be a flagrant non-compliance with the law. And in such a situation, the court will be entitled to invoke the interpretative jurisdiction to hold that the non-compliance of the law is against the recalcitrant party. Of course, it means what happened in that case was that statement was rejected and the Supreme Court ordered a retrial. So the case now is going back to the Federal High Court for retrial. Okoro just added his voice. He said, since the law has provided for a suspect's extrajudicial statement to be electronically recorded and in the presence of a legal practitioner of his choice, it will amount to a violation of the law if that provision is not followed to the letter. The Supreme Court is standing on a ground that yes. You see, the principle of law that where you have two decisions, conflicting decisions of the higher courts, like the Supreme Court, as we have here now, which one is applicable? The simple answer will have been that the last decision of the court should be made applicable. My only problem in this case is the fact that in Nigeria first case, there was no reference to Taiwo's case. It would have been so good if there was a mention of Taiwo decided by the same court in 2024 for us to know that yes, the court took cognizance of that fact. Because tomorrow, we are not sure that another panel may not come up again, with due respect, and come up with, and follow Taiwo again. But if in Nigeria 4, Taiwo has been referenced, they will have said that Taiwo has been overruled. Anyway, so, but the point we want to make here is, very assertively, the Supreme Court in Nigeria 4 has ruled that the law is any confessional statement to be taken must be video recorded. And if it's not possible, it must be in the presence of a legal practitioner or any, well, we don't mention so many amongst the, even including the relatives and what have you, must be present there. So now my comment. Section 29, to me, and section 15.4 and 17.2, they form an integrated process of the admissibility of confessional statements. Distinguishing Evidence Act from Aclrc for purposes of admissibility, to me, is unnecessary. The admissibility of confessional statement encompasses both laws. This should really be, in my view, with due respect, the proper attitude. Don't say a particular law is procedural. It is procedural, but it says you must do something. Does it mean we should not be obeying procedural laws? And how has the provisions of Aclrc conflicted with section 29? So, to me, I see both laws as being complementary. My explanation, section 29 only says you can challenge confessional statement on the basis of involuntariness. So that is one. If a confessional statement was involuntarily made, it should be rejected, of course, after trial. In addition to it, to me, I believe Aclrc now says, in order to prove voluntariness, the easiest way, perhaps you may not need to go in the whole hog of trial within trial. Just come with the video. This is the video. This is how it was recorded. There is a legal practitioner beside him making the statement. So then, what are we talking about? If it was voluntary on the basis of what the court has seen on the video, the court should be able to determine whether it was voluntary or not. So my position is that Aclrc's electronic recording and the presence of a legal practitioner are essential requirements and components for confessional statement, for admissibility under section 29. A judge cannot pick and choose which extant law to enforce. That's section 29, Evidence Act, governs admissibility. No other law, I don't think that is correct. There are many other laws that govern admissibility. So now, section 15.4, 17.2 contain preconditions stipulated by law to be met. And I ask here, what is more? With due respect, it appears to me that in all the arguments and decisions of the interpretation of sections 15.4 and 17.2, section 3 of the Evidence Act is often overlooked. And as a matter of fact, in all these cases, I didn't see anywhere section 3 of the Evidence Act was mentioned. And what does it say? The said section approves the validity of any other Nigerian legislation which provides for admission or exclusion of evidence. And I quote, it says, nothing in this act shall prejudice the admissibility of any evidence that is made admissible by any other law. So what are we talking? That Aclrc is procedural. But Evidence Act has said Aclrc can make law for admissibility. And if Aclrc says, go and bring video before you are a particular confessional statement is admitted, it means that video is a precondition to admissibility. So this is the line of thought that Unajiafo Supreme Court case is establishing. And I think that is what must be followed. So my final submission on the point is that by virtue of section 3 of the Evidence Act, the provisions of sections 15.4 and 17.2 prescribing preconditions for admissibility of a confessional statement shall not be prejudiced on the score that it is a procedural legislation, as we have read in many of these authorities. It should not be a basis. This proposition is predicated on the decision, okay, I have this decision of the Supreme Court in FGN and Anebuewa, where the court approved the authentication of documents in extradition proceedings as prescribed under Section 17 of the Extradition Act and not Section 84 of the Evidence Act. In Anebuewa's case, extradition proceeding, documents were brought before the court. The issues relate to admissibility of those documents in relation to Section 84 of the Evidence Act. But the Supreme Court said no. The Extradition Act has already stipulated how documents in extradition proceedings shall be authenticated. And it is as provided for under Section 17. So are you now going to say that Extradition Act cannot override Evidence Act? We are not talking about overriding, but we are talking about one being complementary to the other. And so, quoting the Court of Appeal minority judgment in that case, at that JCA now, JSC, this is what the Supreme Court said. With approval, under this law, the responsibility of ensuring that documents admitted are from authentic sources, which Section 84 addressed, is also addressed in Section 17 of the Extradition Act. So the only area to know critically is the fact that Section 84 is a municipal law, laying down the text to deploy to assure the authenticity of computer-generated document. But then Section 17 deals with documents authenticated from foreign jurisdiction. So the point I want to make here is that it is not correct, with due respect, to say that if a matter is not dealt with under the Evidence Act regarding this admissibility, no other law can guide it. So the enactment of Section 15 and 17 of Aclrc, to me, is very valid and cannot be. So, and finally, let me just, we have argued so much about this may, and I think it's already treated. And that's just the second question I have answered. And the answer you will find in Taiwo and Unajiafo. Taiwo says may is optional. Unajiafo says may is compulsory. So now, my own final position on this issue is to say that I will commend all this, the one I'm jumping on now, statements of their lordship. The comprehensive and insightful opinion of their lordships, both in Taiwo and Unajiafo, though divergent. Please, I want you to take note of this. I am not saying one is better than the other. I am not saying one is wrong. As a matter of fact, if you read any of them, you will be convinced, you will be carried away. Where the Supreme Court says may is may, you will be carried away by it. Where the Supreme Court says may shall be shall, you will also be carried. So I have made the point here that those views are divergent, no doubt, but the perspective presented, they are well reasoned and they are authoritative. And they deserve to be respected. However, our problem simply lies in the failure to define, of the act to define the word may. The drafters of Aclrc should just have added may under Section 15 and 17 shall be understood to mean shall. Probably that would have resolved all those problems. So instead of blaming the Supreme Court or any court at all for that matter, I will put the blame on the drafters who did not do their job properly in two ways. One, they copied Lagos, they didn't copy well. too, and they didn't define what may, is to stand for. So in the realm of statutory interpretation, the word may be may. So if any court says may, it's correct. It might be discretionary, it can be permissive, it can be optional. The word may also be shall. It can be compulsory and it can be mandatory. What's used in statutes that are not statutorily defined, they are customarily given ordinary meanings. Usually you take resort to dictionary definition. But I am saying here that our dictionaries cannot help us. Courts have often relied on dictionary definitions to ascribe literal meanings to words. But this does not resolve the problem here. Of course, it is well known that the application of dictionary definition is not always clear. We can have a word with 100 meanings in dictionary. So that is not the, it doesn't solve our problem. That is why it is always important to allow context to guide the choice of meaning of words. And that was what the Supreme Court did. The Court of Appeal did it ably in Nigeria 4. And the Supreme Court also accepted it. And so a word in a statute may or may not extend beyond the dictionary meaning. In the context of ACJA, Nigeria 4 is a heartwarming decision. That is my resolution now. So if you ask me, where am I in all this matter? I will stand on the side of Nigeria 4. Nigeria 4 is the decision of the Supreme Court in Nigeria 4 is heartwarming because it has gone beyond the literal meaning of the word may. It has given effect to the broader purpose. In fact, the court went to the point, why was ACJA enacted? He said ACJA was enacted because of the excesses of the police officers. And so the Supreme Court then applied mischief rule and said, okay, if we must cure the excesses of the police, one way we can do it is to interpret may to be mandatory, and may shall be shall. And so it is one of the surest indexes of progressive and proactive jurisprudence not to make a fortress out of literary meaning of a word, but to remember that statutes always have some purposes or object to accomplish, whose imaginative discovery, which is the duty of the court, is the surest guide. In respect of ACJA, court, in exercising the unquestionable power of interpretation, they should continue to give effect to the stated objectives, to cure the mischief that we have suffered in the past. This is the only way we can ensure that confessional statements are obtained and used in a manner that respects suspects' rights and upholds the dignity of the criminal justice system. In today's rapidly changing world, Nigeria's legal framework requires flexible and adaptive interpretations. Our legislators and courts must recognize and reflect this reality, embracing dynamic legal perspectives. This is one way by which we can make our criminal justice system meet the minimum standard recommended by Ogunwumiju JSC in Nigeria first case. And finally, in reviewing these cases, the overarching objective, my basic objective, is to respectfully utilize this esteemed forum to bring to the attention of the Supreme Court the recent cases that I have discussed, where divergent views have been expressed over the vexed issue regarding admissibility of electronically recorded confessional statements. And these decisions, they have significant implications for the administration of justice, and they warrant clarification and harmonization from the apex courts. And I hope the Rule of Law Development Foundation will take up this challenge and draw the attention of the Supreme Court to these cases. and perhaps this review. The review also highlights the need for national and state legislators. I'm also challenging houses of assembly that had enacted administration of justice, criminal justice law to emulate Lagos State's approach, ACJ's approach, by replacing may with shall in relevant sections governing admissibility of electronic confessional statements recordings. This amendment will eliminate ambiguity and clear the law, thereby resolving associated controversies. And I want to add here that if the State Houses of Assembly fail to do that, courts should follow Nigeria 4. Thank you very much.
Thank you very much, my Lord. Distinguished participants, another resounding applause for my Lord. And since we are dealing with confessional statements, let me make a confession. I deliberately did not interrupt my Lord's delivery because I know that I want the distinguished participants to drink from his well of experience and imbibe his depth of knowledge on this topic. And that is why I let him have as much time as he needed. And so I agree. I believe you will concur with my decision that no, I don't want to say time is up, time is off. So my Lord, another round of applause for my Lord. Fine. Before we move on, let me at this point again mention the point, distinguished participants, that I'm placed on record that Chief J.B. DAUDU, the founder and coordinator of the Rule of Law Development Foundation, whom I'm standing in for as chairman for the first session, is participating with us in this session virtually, and we might get his contribution if the need arises when we get to interactive question and answer session. Now, we'll now proceed and take the first paper discussant, whom has been introduced, and is no other person than that man of big stature who is phenomenally renowned for churning out books on evidence. So, Professor Esteon, please, you have the audience.
Thank you, my Lord, the Chairman, and I also appreciate all my lords, the national advocates of Nigeria, and everybody gathered here.
I believe 15 minutes would be okay for you.
My Lord, sir.
You are a professor.
My Lord, sir, I beg. I will try.
Okay.
In fact, I have participated in the Rule of Law Foundation for 3 occasions. The first time it started in 2018, I was there with my Lord. And let me also make one confession here. We agreed on almost all the points in our delivery. 2 years ago, we were here. The same thing happened. Today, when we came, he was asking, where is my paper? I was also asking, where is his paper? It wasn't exchanged. But your laws and everybody here will see that we will agree to a very large extent. That means all that we'll be saying here will reflect sound opinion on what is supposed to be. So my paper is entitled, Is there any need to review or amend the provisions of Section 15 of the Administration of Criminal Justice Act 2015? That is the scope of my paper. I have expressed my gratitude to the organizer and founder, Chief J.B. DAUDU, for doing this yearly. Then in paragraph 2, I must say that when Section 9.3 of the Administration of Criminal Justice Law of Lagos State and subsequently Sections 15.4 and 17 of the Administration of Criminal Justice Act 2015 and similar provisions in some state criminal procedure laws first offered themselves for judicial interpretation, they received conflicting decisions of the Supreme Court, of the Court of Appeal. And I quoted Nigeria 4 at the Court of Appeal, as he talked about it later in the paper. But I quoted it, and if you look at footnote 2, I said, before this decision was handed down, I had taken a similar position in a paper entitled Recent Developments in the Law of Evidence at the Rule of Law Development Foundation Maiden Annual Criminal Law Review Conference at the ICC Abuja. This was on November 21, 2018. I took a similar position as the Court of Appeal took, which was later affirmed by the Supreme Court. I now cited Oguntoyibo against FRN, unreported, where the Court of Appeal held that May was permissive and not mandatory. And I went to page 2, I said, it is remarkable that I severely criticized this decision in my text on the law of evidence in Nigeria, published a year thereafter. Because when that unreported decision that said May should not be shall was rolled out by the Court of Appeal, I criticized them in these words. The above opinion with respect is not correct. As shown above, it is settled law that the word may should be interpreted as shall when it imposes a duty upon a public functionary for the benefit of a private citizen. Moreover, this decision runs against the several decisions of the Court of Appeal analyzed above and is in any case contrary to settled principles of law as enunciated by the Supreme Court as clearly shown above. It gladdens my heart that in 2024, 5 years after I had profiled the above opinion, the Supreme Court of Nigeria, in affirming the decision of the Court of Appeal in Nigeria 4 against FRN Supra, listed the above interpretation of the word may as one of the reasons for its conclusions. Today, I have the privilege of discussing that same decision of the Supreme Court, to wit, Nigeria 4 against FRN. So, main paper discussed. I said that even though it is section 15 of ACJA that is specifically mentioned in the title of the paper, and that was what was directed to me, I found it of utmost importance to also consider the provisions of section 9.3 of the Criminal Justice Law of Lagos State. The reason is that the decision of the Supreme Court in Nigeria 4, Charles and Lagos, while interpreting section 9.3 of the Lagos law, is in pari material with its decision in Nigeria 4 against FRN. Moreover, they say decision in Charles versus the State of Lagos has also been listed by the organizers to be discussed. I now quoted section 9 sub 3 of the Lagos law. On the other hand, even though I'm required to discuss the whole of section 15 of the ACJA 215, I will limit myself to section 15.4 and 5 only, saying subsections 1 to 3 of that section are straightforward and not complicated. I now quoted section 15, 4 and 5. The interpretation of section 15 of the ACJA will not be complete if the provisions of section 17 thereof are left out, because the two provisions go together in most cases. I again quoted that the Apex Court was called upon to make a decision on sections 15.4 and 17.2 of ACJA 2015 in the case of FRN against Nigeria for Supra, unanimously throwing out the confessional statements in issue on the grounds that it breached, or they breached these provisions, Salawa GSC, who delivered the lead judgments. I quoted exactly what my Lord quoted, that dictum. So it is there for you to see. And in his concur, Ogunwumiju GSC relied heavily on the decision in Charles versus the State of Lagos Supra. He agreed on pages 476 to 482 with the orbital dictum in that previous decision that although the word may is used in section 15.4 as against the word shall in section 9.3 of the Lagos State Criminal Justice Law, he still carried the mandatory meaning of shall because of the settled position of the law that courts would interpret the word may as mandatory whenever it is used to impose a duty on a public functionary to be carried out in a particular form or way for the benefit of a private citizen. Similarly, Agim JSC in his concurring contributions heard on page 483 that when the legislation vests a public duty on a public officer for the benefit of any person, the intention is to make the execution or performance of the duty mandatory, irrespective of whether it is permissive or mandatory word that is used to impose the duty. Hence, the word may in section 15 of the Act conveys a mandatory meaning. I quoted him there, his concurring judgment on pages 483 to 484. It is there, we can all look at it. say go down, still go down. You are coming behind. Maybe I'm too fast. They gave me 15 minutes. So yes, that is where we are to the end of the quotation. I shall now review some of the issues in the extant provisions of the ACJA and the position taken by the Supreme Court on those provisions. In the process of doing this, I shall make my suggestions for review or amendment. Ogunwumi GJSC, in his concurring judgment in the case of Nigeria 4 against FRN Suprahead on page 477, that section 15.4 of ACJA 215 was enacted in more elaborate terms than section 9.3 of the Lagos State law. This is true for the following reasons, namely, A, section 9.3 of the Lagos law requires that the confession should simply be recorded on video without specifying the nature of electronic recording, while section 15.4 of ACJA requires that the said statement should be in writing and may be recorded electronically on a retrievable video compact disc, or such other audio-visual means. The latter provision is specific on the confession being recorded electronically, A, on retrievable video compact disc, or 2, such other audio-visual means. B, section 9.3 of the Lagos law contains the following proviso, which is not in section 15.4 of the ACJA. Provided that in the absence of video recording, the said statement shall be in writing in the presence of a legal practitioner of his choice. The consequence of the National Assembly refusing to include this proviso in section 15.4 of the ACJA is that there must be strict compliance with the electronic recording of the confession, whether or not the defendant's legal practitioner is present. That is why the complementary provision in section 17.2 of the ACJA does not provide that the presence of the legal practitioner should constitute an exception to the electronic recording of the confession. I have quoted it again. The above notwithstanding, some amendments to the existing provisions of section 15.4 of the ACJA are hereby suggested in the next subparagraphs. The first one is the word may, as my Lord elaborately delivered here. Even though the word may in section 15.4 of the ACJA has shown above in the case of Nigeria 4 against Federal Republic of Nigeria, been heard, I omitted be heard, to contextually mean shall, I still have my hunch in view of conflicting decisions of the Supreme Court on major issues, including admissibility of electronic evidence. Now, if you go to footnote 8, which is not there on the board, I cited the case of DAUDU against FRN 2018, where Supreme Court held that section 84.2 is not even mandatory. I was so shocked by that decision, with due respect. Now, and then I also, so contrary to existing decisions, because I did silver against INEC from the election tribunal all the way to the Supreme Court, and the Supreme Court heard that it was mandatory. But a year after, that was in 2017, a year after the Supreme Court said it was not mandatory, and afterward, it started saying it was mandatory again. So, not even the word may has been spared this cacophony of contradictory positions. Thus, and I cited only Supreme Court decisions. Why one set of decisions is to the effect that the word may is merely permissive, the others are that it is mandatory. I cited up to 2024 decisions. So the word may presents difficulty in interpretation, conflicting decisions all the way. The surest bet, therefore, is to amend section 15.4 of the Act by replacing the word may therein to shall, to enable it convey a mandatory meaning. I also touched on section 15.5 of the ACJA, and I said it should be deleted. In my paper delivered at the maiden edition of this program in 2018, I strongly advocated that this section be deleted, since it has made nonsense of subsection 4 of section 15. The following year, as I was publishing the third edition of my book on the law of evidence in Nigeria, I again stated very strongly after quoting section 15.4 thus. I will just start from clearly. Clearly, therefore, failure to comply with the provisions of section 15.4 will not render any oral confession obtained from the suspect inadmissible. There's even more confusion here by the use of the phrase oral confession. The unanswered question is whether this phrase is meant to explain the difference between the confession recorded down and the one not so recorded, or whether it is in relation to the video recorded confession, since by section 2581, A video or audio recording is a document. The laudable effort shown in the enactment of Section 15.4 of the ACJA therefore seems to have been watered down by Section 15.5 of the same Act. The National Assembly is therefore hereby respectfully requested to amend the ACJA by deleting subsection 5 thereof. Now, I also advocated, just as the way my Lord did, that there should be definition of terms. If we look at ACJA 215, section 494 is the definition section of that law. As important as the provisions of section 15.4 of the ACJA are, none of the major words or terms contained therein is defined in the Act, and particularly under the definition provisions of section 494 thereof. The importance of carving out a definition provision for these words, or those words or terms, is imperative for the following reasons. A, it will take away the necessity of resorting to other statutes for the definition of such terms. The importance of the statutes containing a definition, section, or provision was stated by the Supreme Court in the case of APC against Moses. Thus, it is trite law that where a particular word or phrase is defined in a statute, its meaning would be as defined in that statute. No other meaning can be given to the word or phrase outside the definition of that statute. So, let the National Assembly amend the ACJA, and other state governments or assemblies also amend to include definition provisions. Now, resort may ordinarily have been to the Evidence Act 2011, including the Evidence Amendment Act 2023 for the definition of those words. But not all of them are covered by the Act as amended. For instance, even though the 2023 amendment defined in this section 10 audiovisual communication, which could be adopted to cover audiovisual means as used in the ACJA, and the electronic record. This phrase is a noun, as opposed to the phrase be recorded electronically, contained in section 15.4 of ACJA, which is the action that would lead to maintaining an electronic record. Importantly, too, the phrase retrievable video compact disc in the said section 15.4 has not been defined, even in the Evidence Amendment Act. A definition be provided for the said phrase to avoid ambiguity. I cited the 2020 decision of the Supreme Court of the Court of Appeal. The paper on the screen is not containing footnotes, but is there where the Court of Appeal defined compact disc, etc., etc. Provisions. The third aspect is that provisions should be made to prevent application of the rule against dumping of electronic evidence. In fact, the Rule of Law Foundation should take this suggestion very important, because criminals will escape if we don't amend the law. And I cited the Supreme, in fact, dumping of documents was limited from decisions to traditional documents. But in 2023, Supreme Court in the case of Tumbido against INEC extended it to electronic evidence. So if you tender electronic evidence, and even if you play it, Supreme Court said, look, you can't just merely dump it. And I quoted the dictum of the Supreme Court on that page. So he said that no court is entitled to conduct inquisitorial investigations into the contents of a document or purport thereof in its chambers. The appellant ought to have called the witness to speak to the photographs and video recording before the court. Can you beat that? So even if you display it, somebody must be speaking to it. Our trial judges, my learned judges are here. This is a guide so far. But honestly speaking, I find that these things should be amended. Since case law has now extended the issue of dumping of documents to computer-generated or electronic evidence, the National Assembly should consider amending Section 15.4 of the ACJA to cater for the lacuna. Otherwise, some criminals will escape justice, even when the case of the prosecution against them is heavily based on such electronic evidence. The National Assembly may add either a proviso or a substantive subsection which raises a presumption that once tendered and played in open court, any such electronic evidence is taken as having been read, thereby sidetracking the issue of dumping on the court. That is my suggestion. It could either be a substantive provision or a proviso. Then the third suggestion is that the National Assembly should categorically indicate whether the video evidence mentioned in Section 15 is electronic evidence or mere documentary evidence. And that's it. Before March 18, 2022, it was generally agreeable that computer-generated evidence was documentary evidence, given the very wide and all-encompassing definition of document in Section 258 of the Evidence Act 2011. I cited Dixon against Silver 2017, which I said I conducted from Tribunal to Supreme Court, and Omishore against Aregoshola. Dixon against Silver was electronic evidence. We brought the tape to play, the evidence, and objection was taken that we didn't comply with Section 84 in respect to even the tape that was to play, not in respect to in respect to the computer gadgets that recorded the something. So, upon all my submissions as overruled, I went to go to appeal, Court of Appeal allowed the appeal, and they appealed to the Supreme Court. The Supreme Court overruled them. But at the same time, the Supreme Court heard, equated video evidence to documentary evidence. This position was, however, routed or altered by the same Supreme Court in the case of Ebanuzo against the state, 2022, which was delivered on March 8, 2022. This was a case where the appellant's conviction was based on 2 written confessional statements and a video recording, SVG. Hence, the decision is very relevant to this discourse. OJGSC will deliver the lead judgment, summed up the appellant's grounds, so it's there. And of all the 3 fronts of attack mentioned in the dictum above, the first and second ones are the only relevant ones to this intellectual outing. The Supreme Court, in view of this challenge, was compelled to differentiate between real evidence and documentary evidence. After citing the Black's Law Dictionary 9th edition on what is real evidence, and after reproducing the definition of document in Section 258 of the Evidence Act, or JGSC, heard as follows. What is the difference between them? Simple. If the document itself is being used as evidence, then it must be regarded as real evidence. On the other hand, if the content of the document in question is being submitted as evidence, it will be regarded as documentary evidence. In this case, the appellant is spot on that SVG, remind you, I said SVG was the video evidence, was tendered and admitted at the trial as documentary evidence. But it is argument that the trial court should not have admitted it in evidence and proceeded to rely heavily in convicting him is based on faulty premise. His argument touching on Section 84 of the Evidence Act is also baseless because that section deals with admissibility of statements in documents produced by computer. SVG is a video recording in which visual images are embodied. It is not a computer output. So the issue of whether the conditions stipulated therein were applied in this case has no place in this appeal. You can see the confusion. In view of the above, therefore, the National Assembly should make an independent provision in Section 15 of the Aclrc 2015 to categorically state that the video evidence mentioned therein is documentary or real evidence, as the case may be, to avoid the confusion set up by the Supreme Court itself. Before I draw my curtain, I wish to just briefly commend my lords for the learned professor of law for a well-delivered paper. And I agree with him. I just want to add 1 or 2 sentences. The Evidence Act itself is also not substantive legislation, it's procedural legislation. It regulates procedure. Substantive legislation has to do with maybe if they are enacting land law or the Constitution itself or something that regulates substantive rights, but evidence means procedural. So I fault the judicial opinion that tries to differentiate. That is Taiwo against FRN. I agree with him that Taiwo suffers from on a lot of fronts. And in fact, when he was delivering, before he could reach Section 3, I was recording it. Because Section 3 of the Evidence Act says that evidence admissible under any other act is also admissible. So it has not, it is not in the place of, it's not correct with due respect to say that Aclrc is procedural and it doesn't regulate confessions. When clearly, even the Evidence Act, unlike the previous Evidence Acts, 1990, 2004, that said Evidence Act was numero uno. This one says allow some other acts to regulate. So, but the previous position has been amended in the 2011 Act. And that is why, if you look at Section 12A and B of the National Industrial Code Act 26, it mandates the court to regulate its procedure and even to depart from the Evidence Act. And I have been appearing before the National Industrial Code. Some provisions, some pieces of evidence that are ordinarily not admissible in the evidence, under the Evidence Act are admissible because the judge will say, no, I am to regulate my own procedure. The Act has mandated me. And so far, they have not been overruled. So the Evidence Act is no more the sole legal regime to regulate admissibility of evidence, confessions. Now, and moreover, as you said, Nigeria 4 is 2024 is the latest. Finally, I recorded here that the 2015 AJA is later in time to Section 29 of the Evidence Act 2011. So if there's a conflict, 2015 AJA will take precedence. And that is settled law by rules of statutory interpretation. So on this call, I conclude as follows. This annual intellectual ritual has proved itself once again to be gravely important. Since confessions form the fulcrum of criminal trials in Nigeria and globally, the assigned topic is of deep importance. I believe that if the suggested amendments are effected by the National Assembly, the resources and efforts put in by the organizers shall not be wasted. In conclusion, I suggest that Lagos State should also take a leaf from these suggestions to effect amendments to its administration of criminal justice law. Thank you all, and God bless us.
Please join me in giving Professor S.T. Horn another resounding round of applause. Like I assured you at the beginning, that having two professors professing to us this morning, we are not going to be left unsatiated. In fact, I am so filled up now that I'm just waiting to top up with what the next discussant, DCP Simon Lau, PSC SAN, will give us the icing on the cake as our, So please, let us welcome and give a round of applause to our next discussant, DCP Simon Lau, PSC SAN. You also have 15 minutes. And I'm sure since we are talking more or less from the practical aspect of the topic, you will do justice to it.
Thank you, my Lord. Since the whole thing revolves on confessional statement, and the police appear to be the most culprit, I believe my Lord will give me more time to explain why. Yes, sir. Thank you, my Lord. Yes, sir. Yes, sir. My Lord, the chairman of this occasion and all other protocols observed. Before I go into the discussion, before I go into the discussion of my paper, I would like to appreciate my Lord Professor Adileye and Professor S.T. Hong for well-delivered papers. In fact, I agree with most of the postulations made by the two professors. And I also agreed most especially with S.T. Hong on the issue that Evidence Act and the Administration of Criminal Justice are both procedural and not substantive and both are complementary and not inconsistent. However, I disagree with my Lord, that is Professor Ajile, when he said the ACJA was enacted to cure the excesses of the police, specifically. Yes, sir. My Lord, the intendment of the promulgation of ACJA is stated in Section 1. Yes, sir. Yes, sir. It's clearly stated in Section 1 of ACJA. It's for speedy dispensation of criminal justice, not to curb the excesses of any law enforcement agency. Yes, sir. So that is the intendment of ACJA. And also, the legislator did not do you said the legislator did not do their work properly in the use of the word may in Section 15, Subsection 4. I believe the legislators were looking at the reality, which I'm going to discuss, the reality on ground. Do we have all the necessary materials and equipment to do the recording as provided on the law? So they use that word, looking at the reality on the ground. Laws are made to be enforced and obeyed, not just for them being in the books. So their use of may, first of all, they use shall, and immediately after shall, they use may. So it was deliberate. So they look at the reality on ground. That is why the word may was used, and I agree entirely with them. So they didn't even make a mistake at all. Yes, sir. And also, and lastly, that is on the comment, and lastly, by the principle of implied repeal, Section 29 of the Evidence Act have been repealed by Section 15 and 17 of the ACJA. We have the principle of implied repeal, where two laws make provision on a subject, they later impliedly repeal the former. So by the principle of implied repeal, that's Section 29 of the Evidence Act, though on admissibility of evidence, has been impliedly repealed by Section 15 and 29 and 17 of ACJA. So now on to my paper. My paper is that's a review of recent judicial decisions on confessional statements in criminal trials in Nigeria, a guide to the recording of evidence of suspect, the practical reality and attitude of the Nigerian police force to the safeguards. We have discussed here, we have talked of evidence, but we did not talk about what is actually evidence. Evidence generally includes any piece or group of information submitted or tendered in court or tribunal or any proceeding in proof or disproof of a fact in issue. The essence of evidence is to clarify the fact in issue and assist in establishing the truth or justice of the case. This could be oral, real, or documentary information relating to the fact in issue that can be determined by the court, tribunal, or the adjudicator. Proof of facts in issue is usually by evidence, and the basic rule of evidence is relevance and admissibility. This is provided in Section 4 and 5 of the Evidence Act 2011 as amended. Thus, for any piece of evidence to be useful to the court or the adjudicator, it must be placed before the court or pleaded, it must be relevant, and it must be admissible. You can see the case of Onjokama there. Before the enactment of the Evidence Act 2011 and its amendment in 2013, issues concerning admissibility of documents generated from electronic devices were highly contentious. Despite the controversies surrounding information generated electronically, documentary evidence have been accepted as admissible in court as evidence and regarded as the best form of evidence, as it eliminates much of the challenges of oral evidence, which in most cases is tainted with half-truth. You agree with me that in most cases, when witnesses come, take oath, you will see they will be, in fact, most of them, the whole story will be, lies. The question, however, has been, what form of document is admissible and the condition for which, for such admissibility under the rules of evidence, i.e. primary, secondary, certified true copy. The enactment of the Evidence Act 2011 and its amendment 2013 has resolved the quagmire or argument of electronic generated information used in court to establish a fact issue. Admissibility of evidence, of electronic evidence under the current Evidence Act have taken into cognizance the dynamics of technological development, which has always been a contentious issue. The Evidence Act 2011 has expanded the repositories of documents to specifically include electronically generated evidence under Section 84, most of which have been discussed by the two professors. What then is electronic evidence, sometimes referred to as computer-generated evidence? That has also been discussed by the two professors, so I will need not go to detail. I even quoted my Lord Omole Ajile, that is my Lord Justice Ajile, in one of his books, which he gave me the other time complimentary, and I thank my Lord for that copy, sir. It has been useful to me. The definition given by my Lord in that book consists of 3 elements. That is, definition of electronic document, as given by my Lord, as quoted above, consists of 3 elements. 1, data is created, manipulated, or stored in a computer. 2, various forms of devices by which data can be stored or transmitted, including analog devices that produces an output. Evidence as information that has the potential to make the factual account of either party more or less probable than it would be without evidence. So that is so far the definition of evidence. In other words, electronic evidence is not limited to that which is found on a computer, but exceeds to include evidence on digital devices, such as telecommunication or electronic and multimedia devices, emails, digital photographs, ATM transactions, word processing, and so many other ones are stated there. Now, on to the main topic, review of recent decisions. I have looked at 4 different cases, that is recent decisions of the Supreme Court. But first of all, let me look at the Act. Before the enactment of the Administration of Criminal Justice Act 2015, admissibility of evidence of suspect, especially confessional statement, was regulated by Section 28 and 29 of the Evidence Act. So Section 28 has already been reproduced there, and there's Section 29. So the subject is to Section 29. In any proceeding, a confession made by a defendant may be given evidence against him, insofar as it is relevant to any matter in issue in the proceeding, and it is not excluded by the court in pursuance of this section. If in any proceeding where the prosecution proposes, this is where the problem is. If in any proceeding where the prosecution proposes to give in evidence a confession made by a defendant, it is represented to the court that the confession was or may have been obtained by operation of the person who made it, or in consequence of anything said or done which was likely in the circumstance existing at the time to render unreliable any confession which might be made by him in subsequent the court shall not allow the confession to be given, and so on. So this is where the issue is. Like the old Evidence Act, you know, even promise was considered to vitiate a confessional statement. But the current act specifically states where there's oppression, and it even went further to define oppression. That is in subsection 3. So for you to establish that the confession was involuntary, you must establish that there was oppression. There are cases which have handled where issues of admissibility have been raised. And the issue were that the defendant was promised that if he confessed, he will not be charged to court. So such promises today amount to oppression as envisaged by this provision of the Act. And most of the cases that were conducted trial within trial, those statements have been admitted, that promises is no longer part of the vitiating factor in the admissibility of confessional statement. I have also looked at, and that is operation have been defined in subsection 5. In this section, operation includes torture, inhuman or degrading treatment, and the use or threat of violence, whether or not amounting to torture. Judicial decision before enactment of ACJ follows the provisions of the Evidence Act. So judicial decisions before the enactment of ACJ, I've cited many of them. We have Hussaini versus the state. They all follow the provisions of the Evidence Act, section 29 of the Evidence Act. So we have Hussaini versus the state. We have Aclrc versus the state. We have Aclrc versus the state. And where our Supreme Court decision, where the Supreme Court held that confessional statement, once it is established that it's direct, positive, and voluntary, they are admissible and can grant conviction. So the enactment of ACJ has brought about innovations that were never included in the Evidence Act 2011. For instance, section 15 and 17 of the Act provided safeguard to recording of evidence of suspects, especially their confessional statement, to ensure their admissibility. So I have reproduced section 15, but I will deal mostly on section 15, subsection 4, which is the subject of this paper. Section 15, subsection 4 said, where a suspect who is arrested with or without a warrant volunteer to make a confessional statement, the police officer shall ensure that the making and taking of the statement shall be in writing and may be recorded electronically on a retrievable video compact disc, or such other audio-video devices. These provisions has placed an enormous duty on the police, especially because the police are the ones that are involved in most of the cases across the country. So there's a duty placed on the police to ensure that the statement is in writing and is video recorded. So I will look at recent cases that this issue was decided. I will first of all look at the case of Ajiboye versus the state, because other cases have been discussed. I'll look at the case of Ajiboye versus the state. The cases of the Supreme Court in the case of Ajiboye versus the state, Toye the line of Taiwo versus FRN, and discussed by my lord. But in this case of Ajiboye, they say the presence of a legal practitioner is not mandatory, that he must be present before the statement of a witness can be admissible. So Ajiboye and Taiwo, the Supreme Court told the same line of reasoning, which means it's not mandatory that you must comply with section 93, subsection 3 of the Administration of Criminal Justice Law, or section 15 and 17. However, in the case of Charles versus the state, and Charles versus the state, and Najuafo versus in the Federal Republic of Nigeria versus Najuafo, sorry. Yes, Charles versus the state. Federal Republic of Nigeria versus Najafo. And the Federal Republic of Nigeria versus Aclrc. You see, these are all Supreme Court decisions. And all of them are, apart from Charles, Najafo and Aclrc are 2024. So, and Aclrc is the most recent, because the law is sometime that is in August this year. So it's the most recent. So, but all these three cases, they toed the line of Charles, in the sense that they all agree or concord that the compliance with section 15 and 17 is mandatory. So all these three cases have now, stated the position of the law with respect to section 15 and the 17 of the ACJA. So there are issues that have been identified in the judgment and interpretation of section 15 and the 17 of the ACJA. So I have identified 5 issues. 1, that the statement must be in writing as well as video recorded electronically in an audiovisual compact disc, which means for the statement to meet with the requirement of law, it must be in writing and it must be video recorded electronically in an audio-visual compact disc. 2, that it must be recorded in the presence of a legal practitioner of the suspect choice or any of the persons mentioned in section 17(2) of the Act. And 3, that the provisions are mandatory and permit no discretion. 4, the failure to comply with the provisions renders the confessional statement invalid. And 5, that the suspect must have been arrested in connection with a criminal offense and must have volunteered to make a statement. So those are the 5 issues that I've identified that must meet up with the requirement of a valid confessional statement. So the practical reality, what are the practical reality and attitude of the Nigerian police force to the new safeguards? So all these are safeguards that are provided to ensure that confessional statements are admitted without the need for trial within trial. You agree with me that trial within trial is one of the most, in fact, potent obstacles to speedy dispensation of justice. There are cases that I've handled. There are 2 cases that I handled personally that lasted for 12 years, because we have 9 accused persons, and we conducted trial within trial for the 9 accused persons. So it took us more than 6 years. We are only conducting trial within trial. In fact, more than 7 years we are on trial within trial. So these safeguards provided by section 15 and 17 are to ensure that those time wasted or delay in the justice administration is cured. Practically, it seems so difficult to comply with the provisions of section 15(4) and section 17(2) of the Act, in view of the paucity or near absence of recording equipment and studios in most police stations across the country. However, the Nigerian police force, being a law enforcement agency founded on law to enforce all laws and amenable to change and innovation, has already keyed into these recent judicial decisions by directing all commands to ensure that video recording studios are set up, pending when standard electronic recording studios are established across the country, to ensure that provisions of section 15(4) and 17(2) of the Act is complied with. So that is the reality on ground. The reality on ground is that we don't have all these recording studios, but temporary one have been provided now across the country to ensure that judicial decisions bordering on section 15 and section 17(2) are complied with, since it's now mandatory that those investigators must comply with. At present, officers have been directed to use available means such as handsets and other gadgets to record electronically electronically confessional statement where where electronic recording studio is not available, which can be downloaded into audiovisual disc for the purpose of tendering same in evidence and playing same in court to show that the confession is in line with the law. You see, this is one of the issues that we have personally, most of the cases, even before the directive, most of the cases that I've conducted, we have used this method. Confessional statements were recorded using handset, and they were downloaded into disk and played in the court. One of such cases is the case of the killing of General Bade, the former chief of defense staff. We used that, and we play it in court, and the court admitted it as evidence. So it is one of the issues that one of the ways that we have taken proactively to alleviate the shortcomings of those sections. It is hoped that in no distant time, funds will be provided by the federal government for all police stations in Nigeria to be equipped with electronic recording materials to meet the technological development and judicial pronouncement on the subject matter. So it is our belief that sooner or later money will be provided, and all our police stations in Nigeria will have recording equipment, so that the issue of argument as to whether may or shall will not even arise. There will even be no need to even amend the provisions of the ACJ, where the law enforcement, that is especially the police, comply in total with the provisions of the law. There will be no need for all those things. We have taken note that shall, may has now been interpreted as shall, and we are bound by it. And I believe all of us here, including judges, are bound by that pronouncing of the Supreme Court. So I thank you very much for listening.
Thank you so much, DCP Simon La. Please give him another round of applause. We really appreciate your presentation, and it was done within time. You did not require the extension of time granted to you. So at this point, we will proceed with the interactive sessions, where we'll be taking questions and answers, and both virtually and physically. Please limit your questions, comments to just one question per participant, and comments 2 minutes. I will need the assistance of the moderator.
Thank you very much, Honorable Justice Oredola. We thank the discussants for the beautiful discussions. We thank them for their contributions. We've learned a lot. We've learned a great deal. I myself have learned a lot, specifically the need for the legislature as the custodian of our laws to be proactive. You know, they enacted the ACJ in 2015, and over 9 years after, we're still grappling with some basics. The DCP has told us that the Nigerian police force would improve and they will buy all the gadgets needed. However, you know, as the legislature, the judiciary, we have to push the executive as part of our checks and balances. If you make these laws and say it's mandatory, the executive, the police would have no choice but to make budgetary allocations required for all this. We thank all discussants. We want to recognize, before we take contributions, just recognize the presence of our distinguished guests who walked in during the program. Honorable Justice Celestine Odo of the High Court of Federal Capital Territory, we welcome you. We earlier omitted Honorable Justice A.O. Salisu of the High Court of KOGI State. We also welcome you. We want to welcome D.C. Enwelum, Senior Advocate of Nigeria, to the program. You're very welcome. We want to welcome magistrates from the KOGI State Judiciary and directors from the Ministry of Justice who are watching us from the glass house of the KOGI State government, where we'll take contributions very shortly. We also want to welcome Mr. Anozie Obi, Senior Advocate of Nigeria. Sorry, MNI. I apologize. Mr. Anozie Obi, MNI. MNI. Please, now would take contributions from people who are here present. While we wait, we've sent requests for contributions from the Glass House of Kogi State. Oh, nice. My Lord wants to make a contribution.